Good afternoon, everyone. Sorry, I just had some technical difficulties there, but welcome to this month's Employee Benefits Compliance webinar. As we get started, as we've done in the past, you'll see two polling questions that are going to pop up on your screen. We're curious on some of your perspectives as it relates to compliance, how concerned your organization is about compliance scrutiny, and do you expect your organization to make any changes because of that rising regulatory scrutiny that we have been seeing recently? Please take a moment, answer both polling questions. They're just radio buttons, so it should be relatively easy for you to provide your response. And as you're doing that, I want to again welcome you to our webinar today. I'm Dan Gowan with AssurexGlobal. Today, the Loomlight team is going to be discussing ERISA and Cafeteria plan documents. We're going to get into that content in just a moment. As we are getting started, we also like to extend a special thanks to the local insurance benefits advisors and consultants who are partners of AssurexGlobal, and we'd like to thank them for making today's webinar possible. We, as always, welcome your questions. If you have them during the presentation, please submit them using the Q&A function at the bottom of your screen, and we'll address as many of those as we can get to during our time today. If you've just joined us, you'll see those two polling questions up on your screen. If you wouldn't mind, please provide quick responses to those. We'd appreciate it. I'd also like to remind you that these sessions are recorded. A link to the recording, as well as a copy of the slides, will be available early next week from the benefit advisor who invited you here today. And in a moment, we will drop a link to the presentation slides in the chat section in just a moment. I'm going to leave the poll up for just a couple more seconds. Again, thanks for responding to those. We always publish the results from these polls in various formats, including our monthly market check surveys. They're a great way to get timely pulse on how other employers are thinking about the topics that we're inquiring about. Please reach out to the benefits advisor who invited you to. That, we're going to go ahead and close the poll. And concern, doesn't seem to be a lot of concern out there. About 41% are slightly concerned, and another 37 aren't at all. So that's good to see. That means everybody's probably on top of what they need to do. With that, we're going to get into today's content. Joining us from Loomlight are David Flatten, who's Senior Compliance Consultant, and Brianna Barnett, who's the Compliance Advisor with the Loomlight team. David, I'll pass it over to you. Take it away.
Thank you very much. And I'm actually going to pass it over to Brianna because she's starting us out today. So we are going to do a couple of things on ERISA and Cafeteria plan documents, but take it away, Brianna.
All right. So again, we're going to go ahead and just begin with ERISA plan documentation and a little bit of background regarding what ERISA actually requires. So starting with who are ERISA covered employers. So in general, all employers are subject to ERISA, but there are a few important exceptions to keep in mind. Government employers like counties, cities, and school districts are not covered. Churches are also exempt, and that exemption often extends to church-affiliated organizations, such as religious schools or hospitals. Certain tribal-related employers also fall outside of ERISA's requirements. And even though these non-ERISA employers don't technically have to follow the same documentation rules, it's still a best practice to have proper plan documents in place. Without them, again, whether ERISA requires them or not, it's just difficult to administer benefit plans correctly, and it's also difficult to ensure that employees understand their benefits. So here, again, the key takeaway is that while most employers are covered by ERISA, it's key to understand whether your organization falls into one of these exceptions or whether it is an ERISA covered employer. So now that we've talked about which employers are covered by ERISA, let's look at which plans fall under ERISA's rules. So the answer is many, but not all. Health and welfare plans offered by an ERISA covered employer are subject to ERISA. This includes most medical, dental, vision, disability, and life insurance plans. It's also important to note that pension plans are covered by ERISA, but those fall outside the scope of what we're focusing on today. There are also some non-ERISA plans that still need to be in writing because of other laws, Examples include things like POP plans. We're going to discuss that towards the end of this presentation, qualified educational assistance programs, and qualified adoption assistance programs. So here we can see the difference between ERISA plans and non-ERISA plans, which can sometimes be a bit confusing since many employers offer a mix of both. So on the left side, you'll see examples of ERISA plans. So these typically include most of the core employee benefit programs, such as medical, prescription drug, dental and vision coverage. HRAs and health FSAs are also ERISA covered, as are telemedicine plans, life and AD&D insurance, and disability plans, though only if they're fully insured or funded. Other examples include business travel accident plans, hospital indemnity, critical illness coverage, and employee assistance plans. You'll also find things like prepaid legal services, on-site medical clinics, daycare centers, etc. Versus on the right side, we'll see some non-ERISA plans. So these tend to include benefits that are either governed by other laws or paid out of general assets. Examples here are cafeteria or POP plans, dependent care FSAs, transportation plans, HSAs, and identity theft protection. You'll also find programs like adoption assistance here, pet insurance, and various forms of paid time off, which are not subject to ERISA. State mandated paid leave programs and educational or tuition reimbursement plans also fall into this group. So moving on to documentation, first, it is important to note that all ERISA plans must be in writing. This isn't optional. The law requires a formal written plan document that outlines the plan and how it's structured and administered. In addition, every ERISA plan must have a summary plan description or SPD. The SPD is a key document because it communicates the plan's details in a way that's accessible to employees, and it's in a way that employees can actually understand. So it explains eligibility, benefits, and exclusions, basically everything participants need to know about their coverage under the plan. Now, when it comes to disputes or inconsistencies, the plan document will generally control since it's the legal foundation of the plan. However, if the SPD and the plan document ever conflict, the SPD will often prevail since it's the document provided directly to employees. So sometimes to avoid confusion or possible legal issues, we see employers choosing to make the SPD and the plan document virtually the same. That way there's no risk of conflicting information.
Just to give a little historical background, I mean, if you were to go back 30, 40 years, the intent always was there would be a plan document and an SPD. But then, as Brianna mentioned, as what happened is we litigated, and what the court said was, well, since the employees see the SPD, if you say something in the plan document that you don't say in the SPD, well, the employee never saw that, and so they wouldn't enforce the plan document. And if you're a lawyer, what are you going to tell your client in that situation? You're going to tell them, don't leave anything out. So that's how we get to today, where the summary plan description usually is the plan document, which can be really confusing if the SPD says this is a summary of the plan document when in fact it is the plan document. But we will occasionally still see that there's two separate documents, but just be aware more often than not, there's just the one document. Sort of, right?
Sort of is always the answer, right? So, but continuing the discussion of ERISA plan documents in a more general sense, it is important to understand that there are multiple parts here. For example, a plan document may cross-reference other materials like an employee handbook or specific company policies. And when that happens, those referenced materials become part of the official plan documentation. Similarly, some of the information that's legally required to be included in the SPD might actually appear in other documents, such as a group master contract, a group application, or a plan setup document. Now, for fully insured plans, the certificate of coverage that's issued by the insurance carrier is often used as the SPD. However, it's important to note that these certificates frequently don't include all of the elements that ERISA requires to be in an SPD. So this includes things like plan administrator details or participant rights that might be missing from that actual certificate. So again, here, the main point is that employers and plan administrators need to review their documentation and review it carefully to make sure all required ERISA information is included, even if they are relying solely on those carrier certificates. ERISA sets some very specific requirements for what needs to appear in an SPD. Here we can see, a laundry list of those things that have to be included. On the left side, you'll see the elements that apply to all plans, and on the right, you'll see the additional items that are specific to health plans. So for all plans, the SPD has to include basic identifying details like the plan name, number, the name, address, and EIN of the plan sponsor. It also needs to describe the type of plan, how it's administered, for example, whether it's insured or self-funded, and who the plan administrator is. Other required details include the plan year, eligibility provisions, what benefits are offered, and what happens in case of a loss or denial of benefits. The SPD must also outline things like amendment and termination provisions, how claims are handled, and the plan's funding sources. It should include a statement of ERISA rights, and if assistance is available in another language, that information must also be included as well. So for health plans, again, on the right side, there are a few extra requirements. So these include details about cost sharing requirements, annual or lifetime limits, preventive services, and drug coverage. So it should also list network information, any limits on choosing providers or accessing emergency care, whether pre-authorization review is required. And finally, health SPD specifically must include things like COBRA rights, disclosures under other federal laws, and if relevant, whether the plan has grandfathered status under the ACA. So again, ERISA just requires SPDs to be both comprehensive and clear, especially in the context of health plans.
I guess as to the so what question, what's the importance of this? So we know we have this legal requirement, but why? Why does it matter that we have this SPD and then it's got all this information in it? So, a few things. First of all, ERISA does require that the SPD actually be distributed to participants, and it requires that it be distributed upon enrollment. And then if it changes, you have to distribute it again. And then also upon request. And participants can make a formal ERISA document request. And part of what they can ask for is a formal copy of the SPD. Interestingly, there's no penalty for failure to distribute up front, but there is a penalty if you get a formal request, $100 a day if you're late in delivering a proper SPD. And if what you send somebody is your little 2-page benefit summary and say, that's my SPD, well, no, it isn't. And so you're potentially starting to look at penalties if you can't respond with a proper SPD. Also, you are required to then follow the terms of the plan document, which again is very often going to be the SPD. And if you don't, failure to follow those plan documents as they are written is a breach of fiduciary duty. The employer can be held liable for either they themselves are not administering the plan correctly or allowing their agents, like their TPA, to administer the plan incorrectly. And then finally, in the event of a dispute, it is that plan document that is going to control. It's not your benefit guide. It's not what the HR person told the employee. It's what's in that document. And if that document promises something to employees that's not being delivered, the employees can sue for those benefits. So if your SPD says everybody who works 30 hours a week is eligible, but you're only offering coverage to people who work 35 hours a week, the employees can sue to enforce that 30 hours a week. So what's your role as the employer in all of this? Obviously, we recognize that most employers rely heavily on their professionals, on their experts, their brokers, the insurance company, their TPAs, various vendors will often be hired to put these documents together. And we get it. You're paying for their expertise, but that doesn't mean you kind of get to wash your hands of it and say, well, it's not my responsibility. What is your role in this process? One is, first of all, to just recognize what documents do I need and ensure that they are in place. Where is the SPD for my disability plan? Which documents are the SPD for my life insurance plan? If there's multiple documents, do I know where to find them all? Do employees know where to find them all? So it's fundamentally your job to make sure that the documents are in place, even if you're hiring somebody to draft them for you. It's your job to make sure they're there. The other thing I would encourage, and unfortunately we see this a lot of this stuff is kind of boilerplate generated by a program, and the employer gets it, puts it in a desk drawer and never looks at it. And those things, because they're boilerplate very often, they could be saying you're doing all sorts of things that you may or may not be doing. Okay? So it is important that you actually read through the documents as they're provided to you, make sure they're accurate, see if there are inconsistencies or errors, try and get those fixed. Or if the document says we do things this way, well, you either need to do things that way or modify the document. Ultimately, it's also your job to distribute these documents as required by ERISA, and maintain records to prove that you did it. So it may be that you can do an electronic distribution and post it on an intranet and just send an email around. We'll talk more about that later. But you need to be able to prove that you actually did that. You may not, if you get to a situation where a document wasn't properly distributed, the court might not let you enforce what's in that document that if the employees never saw it. The other important thing that I think does fall on the employer, it's kind of your job to recognize when documents need to be amended or modified. Yes, I expect your broker to help you with that too, but you need to understand that we just changed our health plan. Obviously, we need a new SPD from the carrier, but does it affect our wrap document, for example, which we'll talk about later. So it is ultimately your job to recognize we've changed something. And so our documents need to be amended or modified and updated to reflect whatever that change is. And again, you may rely on somebody else to help you draft it, but it's kind of initially on you to recognize this needs to be changed, this needs to be updated. So speaking of wrap documents, let's talk about those.
Yeah, so as David noted, wrap documents also play a role here. So while wrap documents aren't technically required by ERISA, they do serve three key purposes that make them extremely valuable for employers. First and foremost, they help control the number of plans that employer has to file. So without a wrap document, each plan with more than 100 participants needs to file its own Form 5500. A wrap document combines multiple benefit plans like medical, dental, and vision into one single ERISA plan. So this means you only have to file one Form 5500 instead of several. Secondly, wrap documents also supplement component plan documents. So they fill in any missing ERISA required elements that might not appear in carrier or vendor materials. For example, the wrap document might add eligibility rules or details about maintaining benefits during leave of absence, things that may not be covered elsewhere. Third, wrap documents can be used to modify component plan documents. So this helps ensure consistency and alignment across all plans, so they reflect the plan sponsor's design preferences. However, it is important to remember that wrap documents generally can't expand coverage. They can only restrict or clarify what's already there. Also, they usually can't override plan features that are controlled by the carrier or TPAs like claims procedures or exclusions. So again, the wrap document can't expand coverage, but it can restrict or clarify what is already existing. So when a wrap document is created, it's actually forming a new ERISA plan by combining multiple existing component plans, again, like medical, dental, vision, into one single plan. Because of that, the wrap document needs its own SPD. It's important to remember that a wrap document is not a standalone document, so it has to be read and applied together with the governing plan documents for each component plan. So think of it as an overlay that ties those separate pieces together under one unified ERISA plan. Before adopting a wrap document, it's critical to review it carefully. You want to make sure that it's consistent with the component plan documents, or if it overrides them in any way, that those differences are intentional and that they're compliant. So this review also helps ensure the SPD meets ERISA's requirements. Finally, and importantly, employers should think strategically about which plans to include under a wrap. Are all component plans being wrapped? Should they be? And does it make sense to have more than one wrap document depending on how benefits are structured? So the key is that a wrap document, or excuse me, a wrap SPD equals the wrap document plus the component plan documents. And together they create that one single compliant ERISA plan.
And if you think about it, this is where the term wrap comes from. What the wrap document is doing is wrapping around all of those components to make it into one single plan. Okay. And if we actually have a visual of that on the next slide.
Yeah, so this gives a good picture of what the wrap document actually does. So on the left side, you'll see what happens without a wrap document. So each benefit, again, like medical, dental, life insurance, short and long-term disability, and a health FSA, is treated as its own separate ERISA plan, which means that the employer would need to file 5 separate Form 5500s, one for each plan, one for medical, one for dental, life insurance, so on. Now, on the right side, here we have those same, go ahead, David.
Nope, go ahead.
Okay, yeah. We have those same 5 benefit components, but they're all included under a single wrap plan document. So when you create a wrap document, it combines all of those individual benefit plans that you see on the left into one unified ERISA plan. So again, instead of 5 plans, you now have one plan with 5 components, and that means filing only one Form 5500.
So somebody's asking, what is a 5500? So you can sort of think of it as like an informational tax return for your benefit plans. Any ERISA plan that has more than 100 participants is required to file a 5500 with the Department of Labor every year. So again, this is where this becomes important. If the 5 plans on the left all have 100 participants, that's 5 different 5500s you have to file, one for each one. Whereas if you wrap it, since you only have one plan now with more than 100 participants, now you only need one 5500. Most vendors charge based on the number of 5500s being filed. So you can see that wrapping it into a single plan is going to be just cheaper, frankly, but less work and less effort. So now, frankly, that controlling the number of plans is the primary reason I think most brokers and employers, if you ask them, what are you doing with this wrap? Why do we have a wrap? That's what they're usually thinking about, is that 5500 issue and trying to reduce the number of 5500s that need to be filed. But that isn't the only thing that the wrap is doing, okay? At least not a good wrap anyway. As we mentioned, a lot of times, particularly the boilerplate documents you get on fully insured plans are going to be full of gaps. They're going to be missing information that's required to be included in a proper SPD. So the second thing that the wrap is doing is it's actually filling in those gaps. It's providing details that is required by ERISA, but may not be in the underlying documents you get from the vendor. So it's particularly like, for example, a lot of plan identifying information. The little thing you get from the vision plan carrier may not have the agent for the service of process, your EIN number, some of that stuff that is required to be in there. So the wrap document is helping to fill in some of those holes in the underlying component plans. The other thing it can do is it can provide details where the underlying component plan may be lacking. It may not be a gap per se, but it may not answer important questions. So one example I like to give is the waiting period. Let's say you've got a waiting period that's first of the month after 60 days. One question we'll get is, well, how does that work when somebody goes from part-time to full-time? Is the waiting period measured from date of hire, or is it measured from the date the person goes to full-time status? Ideally, that should be addressed in the plan document. Very often, it isn't, not when you go look at the component plan document. So you can use the wrap document to kind of help beef that up and explain this is the way we interpret it, okay? Leaves of absence. Do benefits continue during a non-FMLA leave? Most plan documents you're going to find are silent on that. You can use the wrap, among other things. You can do this other places, but the wrap can be one place where you can have that to say this is the way this is going to work. Eligibility provisions. If you use look-back measurement to determine eligibility, you can describe that in the wrap document. And particularly if you intend to use that for all the benefits, the wrap document is a convenient place to do it because it's wrapped everything together. We can describe it once and then it applies to all of the benefits. Which is kind of the last point, is that it can help ensure consistency as long as there's no conflicts with the underlying component plans. But at least where there are those gaps or those details to be explained, we can describe it once and then again apply it across the board to all of the different benefits. Now, closely related to that then, most of the time when we're doing a wrap, like I said, we have to incorporate those underlying component plan docs, and usually we're taking them at face value. In other words, whatever details do exist in the component plan document, usually we're just going to incorporate those as is and follow what that component plan says. But there are circumstances where you may not like what it says in the underlying component plan document and you want to change it. Well, if you're self-funded, you have a lot more flexibility to change the documents. It may cost you something, but you can usually change it. When you've got a fully insured plan, and again, you're relying on that certificate from the insurance company, they will almost never agree to change those because they've had to file them with the state. They're standard across their entire book of business. It's unusual to be able to convince a fully insured carrier to change their boilerplate materials. And so sometimes what we can do is we can use the wrap document to accomplish that change when the fully insured carrier won't change the document for us. Now, the kinds of things you can change using the wrap are limited, okay? I don't want you to think that you can just willy-nilly completely redesign your plan through the wrap document. That's just not true, okay? In particular, what we're talking about, things that can be changed, are things that were within your control. Things like eligibility, like leaves of absence. Those are the kinds of things that you can potentially modify using the wrap document. You're not going to be able to change things that are within the carrier or the TPA's control. Things like, what is covered, what's excluded. They administer it. You can change your wrap, but they're not going to administer it that way, okay? Claims procedures, you're kind of at their mercy. It's their procedures. So that's the first thing. It's only things that really are within your control that can be changed. And then it's also a question of what can you do? Can you dial it up, that is provide more benefits, or dial it back and take benefits away? Generally speaking, you're not going to be able to amend the plan document to add benefits that are not in the component already, okay? Because again, the carrier doesn't have to honor that. What you can do is reduce coverage, and eligibility is a prime example of that. So my example I've got here is domestic partner coverage. Maybe your carrier automatically includes domestic partners in the list of eligible employees, or eligible dependents rather, but you don't want to cover domestic partners. I don't want to deal with the taxes. It's just a hassle. Different states have different rules. So you may just want to say, we're not going to cover domestic partners. You can put that in the wrap document to say, eligibility is as described in the component plan, except domestic partners are not eligible. And that should work. Now, just fair warning, if the employee calls the carrier and says, can I enroll my domestic partner? They're going to say, yeah, because it's in our document. And that's where the wrap becomes important, because when the employee then stomps into your office and says, the insurance company says I can do it, it's the wrap document that you point to that says, yeah, but we changed that. No, you can't. Now, it doesn't work the other way. Let's say, for example, your underlying component plan doesn't cover domestic partners. You can't just willy-nilly say we're going to cover domestic partners, because the insurance company doesn't have to honor that. And so you could be enrolling people they don't consider eligible, and if they find out, they potentially start denying claims. Okay. So there are some changes you can make, although, again, like I said, it is a little restricted, it is a little limited. So common content, again, these are all different, but you're going to find some fairly common similarities across wrap documents. They almost all have a table, a chart, an appendix, what have you, that has plan identifying information, the plan name, the plan number, the plan year, your EIN, type of benefit covered. Eligibility rules, almost every wrap will either reiterate or again clarify what the eligibility rules for each of the components. Again, we frequently see leaves of absence addressed in wrap documents. This is also, even though it's very often a duplicate, we make sure we put in all the ERISA, the COBRA, the HIPAA notices. That way, if any of the components are missing those, it's covered in the wrap document. Claims and appeal rules. Again, most of the time, the component plan document is going to have that information, but there are gaps sometimes. I mean, I run across, for example, let's say you've got a self-funded major medical plan, you carve out the drugs and farm that off to a separate PBM, pharmacy benefit manager. Well, if there's a dispute over a drug claim, your regular TPA isn't going to handle that in their process because you've carved it out. But depending, I've worked with PBMs that basically have no claims and appeal processes or nothing written in their documents. So you've got a gap. Again, that's where the wrap can help fix that. All right. So we've actually had some of these questions coming in, so let's touch on them. Wrap FAQs. So one thing we get asked a lot, should all component plans be automatically included in the wrap? And the answer is not necessarily. You know, part of it is to think about, go back to why are you doing this? What are you trying to accomplish? You know, for example, you may not want to include non-ERISA plans because they don't have to file a 5500, right? You may not want to include the plans that have under 100 participants. Again, they're not required to file a 5500. So it isn't necessarily required that you include all of the plans. But if you think about the other purposes that wrap is serving, if you're using the wrap to fill in SPD gaps, then it doesn't matter if you have to file a 5500 or not, right? The gaps are there. So it might make sense to include everything in there. What about non-ERISA plans? You know, for example, one great example is a dependent care account, a DCAP. A DCAP is actually not an ERISA plan. So would you have to put the DCAP in the wrap? No. But for a lot of employers, they kind of view this as being a summary, another summary of all of their benefits, and it seems a bit weird to leave the DCAP out of it. So you absolutely can put non-ERISA plans in there. Our advice is, ideally, though, if you do that, you have what we call an ERISA disclaimer, which says basically just because we include a non-ERISA plan in here does not make that subject to ERISA. Do I have to have only one wrap? Can I have more than one? You can have as many as you want. You are controlling the number of plans that you've got. Now, generally speaking, our goal is we want one plan, so we'd only want one wrap. But there are circumstances where that may not be true. For example, if you have a union population and a non-union population and they have very different benefits, you may not want to wrap the two sets of benefits together. Not only are you advertising to the other group what's available, but it gets confusing when you start, particularly when you start talking about eligibility, to say, okay, union employees get this, non-union employees get that. It might be easier in that case to have two different wraps, one for the union, one for the non-union, even though it means two 5500s. That's still better than 20, right? Control groups where there are different benefits for different companies will often have more than one wrap document. The other thing we get asked is, well, I only file a single 5500 and I don't have a wrap document. Isn't that okay? Well, technically the answer is no. Without a 5500, you cannot list more than one benefit on the same 5500. Do lots of people do it? Yes. Do they very often get in trouble? No. But if the DOL catches you, the penalties for failing to file a 5500 are astronomical. I'm not kidding when I say thousands of dollars a day that you didn't file a 5500 that you should have filed. So if you discover that that's what's happening, get a wrap document and put it in place as quickly as possible. Okay. Now, the other thing then related to that is to say, oops, I've been filing it this way all along. Can I adopt this wrap document retroactively? And technically the answer is no. You actually have to wrap a plan before the start of the plan year. So you're not even supposed to do it mid-plan year. Everybody, frankly, people retroactively wrap stuff all the time. Usually we take it's the excuse as well. We clearly operated it as a single plan. This was just an oversight, or maybe we had a wrap at one point. We just don't know where it is. So people do it, but just be aware, if you're working with a vendor, they may very well tell you, no, you're not allowed to do this retroactively, and they're not wrong. All right, so let's talk about amending and distributing. Brianna's going to take this. Somebody did ask the question, what's an SMM? Well, here we go.
Yeah, here we go with an answer. So in terms of amending and distributing SPDs and wrap documents, so SPDs and wrap documents must be updated anytime there's a material change to the plan or how it's administered. When that happens, employers have two options. They can either issue a completely new SPD, or they can provide what's called a summary of material modification, or SMM, which simply describes what's changed in the existing SPD. ERISA also sets a timeline for these updates. So an updated SPD that includes all previous SMMs has to be distributed every 5 years if the plan has been amended during that time, or at least every 10 years if no changes have been made. If the wrap document itself changes, for example, if new benefits are added or plan administration is modified, employers need to issue either a new wrap SPD or an SMM reflecting those updates. So what exactly needs to be distributed? Employers are required to distribute the SPD to participants and beneficiaries, along with any SMMs that describe plan changes. The same rules apply to wrap SPDs. They must be distributed in the same way and within the same time frames as any other SPD.
So that somebody asked, do we have to distribute the wrap to employees? Yes, you do. It's not just sitting in a drawer. The other thing that's important is, and we're going to talk about on a slide or two here, I mentioned earlier, employees can make a document request and ask for a copy of the SPD. When they do that, it is important that you not only provide, if they're asking about the health plan, that you provide the component SPD, you need to provide the wrap as well, because that is part of it. So just to reiterate what Brianna said, the wrap SPD has to be distributed at the same time and in the same way that any other SPD has to be distributed.
And ERISA also sets some specific timing requirements, delivery methods, and procedures for handling participant requests. So starting with timeframes, an SPD must be given to new participants within 90 days of when they become covered under the plan, and to beneficiaries within 90 days of when they first start receiving benefits. If the plan is newly established, then the SPD must be distributed within 120 days of the plan's effective date. When a change occurs, a summary of material modification, again, also just called an SMM, must be provided within 210 days after the end of the plan year in which that change was adopted. If the change results in a material reduction in benefits, the SMM has to go out much sooner, which is within 60 days of the change. Again, with the material reduction in benefits, the timeline shifts dramatically, right? So within 60 days of the actual change, as opposed to when a change occurs that's not a material reduction, it has to be sent out within 210 days after the end of the plan year in which that change was adopted. So that's a very different time frame. It's worth noting also that courts may prevent a plan from enforcing amendments that weren't properly communicated before a claim was made, even if the SMM was technically sent on time. So it's key to make sure that those timeframes are adhered to make sure that those changes are actually taken into effect. Now, moving on to electronic distribution, employers can deliver SPDs electronically, but there are some conditions. Employees either need to have regular work-related computer access, or they must give consent to receive documents electronically. Acceptable methods include email, secure internet postings, web-based portals with notifications, etc. And regardless of the method used, employees always have the right to request a paper copy. This is what David was alluding to. And if they do request certain copies, a participant must receive those materials within 30 days. So again, if a participant requests those documents, that request has to be fulfilled in 30 days time.
And one thing worth emphasizing, because we got several questions about electronic distribution, that first requirement there that the employee has to have regular work-related computer access, what they mean by that is the employee uses a computer as part of their regular job duties. Not we have computers everywhere in the office, or they have it, there's one in the break room they can use. That doesn't count as regular work-related computer access. The reality is, for most employers nowadays, most employees are using a computer in some way, shape, or form, and so they'll meet that first criteria. But you're still going to have people who work on an assembly line or cleaning staff that really don't use a computer as part of their job, and they will not satisfy that first requirement. And in that case, you have to get their consent to deliver it electronically. And if they won't give it, then it has to go out on paper.
So yeah, in this last section, we're going to touch on POP documents. We've alluded to it before early on in the presentation, but POP just stands for Premium Only Plan Document. Okay. So to offer employees the option to pay for certain benefits with pre-tax dollars, again, like health insurance premiums, HSA contributions, or any other similar benefit, an employer must have a Section 125 cafeteria plan in place. And by law, that plan has to be in writing. So that's where the POP document comes in. The POP document is the written plan that outlines how those pre-tax deductions work. So it covers things like pre-tax insurance premiums, pre-tax HSA deductions, and sometimes even flex credits or cash in lieu benefits if those are offered. Essentially, the POP document authorizes the employer to process those deductions before taxes are withheld. No POP document just means no pre-tax premiums. So without it, all those deductions would have to be taken after tax, which eliminates the tax advantages for both the employer and the employee. It's common for a POP to include two parts, a main boilerplate document that covers general legal provisions, and a setup sheet or adoption agreement that outlines the plan-specific details, like the employer name, plan year, and eligibility rules. So here are a couple of other pre-tax benefits that also require plan documents. Here we're specifically talking about health FSAs and DCAPs. So both of these plans have their own documentation requirements. First, a health FSA is considered an ERISA plan, which means it must have its own ERISA compliant SPD. A DCAP, on the other hand, falls under the IRC Code Section 129 rules, which also requires it to be in writing, even though it isn't subject to ERISA. Sometimes these plans are included within a POP document, but in many cases, they have their own standalone plan documents. So it's important to note that even if they're separate, a standalone health FSA or DCAP document is not the same thing as a POP document. They serve different purposes and fall under different compliance rules. Also, while a wrap plan document might be used to bring multiple ERISA plans together, a wrap document itself also is not a POP document. So you can technically incorporate a POP plan into a wrap document, but most employers choose to keep them separate for clarity and for compliance purposes. So in short, FSAs, DCAPs, and POPs all deal with pre-tax benefits, but each requires its own distinct documentation, and knowing the differences between them is essential for proper plan administration.
And I think that is crucial to, if you've got somebody who's administering your health FSA, for example, maybe you hire your payroll company and they handle that. If that's the only thing they handle, there's a reasonable chance that the document they give you is only going to cover that health FSA. It does not necessarily have everything you need for a valid POP document. So unless you've got a cafeteria plan administrator, if you've got a TPA that's just administering individual components, review those documents carefully because it may not be enough. And then the other thing, we get even brokers asking, well, I did a wrap. Do they really need a POP? And the answer is, yeah, they do. They're two completely different things. They're serving two completely different functions. And so unless you deliberately put them all together, you do need both. So what goes in this POP document? So most of the time, I think, as Brianna alluded to, there's a lot of stuff that's very standard and very boilerplate, and that very often goes in, as the main document is a standard document that doesn't vary across employers, and very often doesn't change over time. But there's a surprising number of things that you can customize that are employer plan design choices, which that's part of what the POP document is doing, is documenting what those choices are. And again, very often those things that can vary are put off in a separate setup agreement or some other document where you spell out, here are the options that I'm choosing. But just to give you some idea, so the IRS sets maximums for DCAPs and health FSAs, how much employees can put in them, but you can set it lower than that. So you can use a document to set the max annual election amounts. Plan years. The plan year for the cafeteria plan usually will follow the underlying benefit plans, but it doesn't have to. So you document that there. Who can participate in the POP? That may seem straightforward, and in most cases what it says is if you're eligible for the underlying benefits that are being paid for through the POP, you're eligible for the POP. Well, what about a terminated employee who's getting severance pay? They're not eligible for your underlying benefits. Can they pay any benefits through pre-tax deductions out of their severance pay? Or what about a COBRA participant who's had a reduction in hours but still works for you? Can they pre-tax their premiums? They can, but the document has to allow for it. There are benefits that you are allowed to pre-tax, but we generally recommend you don't do it. For example, short-term and long-term disability benefits can be pre-taxed, but if you do that, the disability benefit itself becomes taxable. So there are benefits that you may not want to include in the POP document and not have them be pre-tax, even though they could be. If you offer a cash in lieu benefit or you do employer flex credits, those need to be described in the POP document. Probably the biggest thing that the POP document covers is mid-year election changes. When somebody makes a pre-tax election, whether that's premiums, health FSA, DCAP, they cannot change it during the year. It's fixed, it's locked for the entire year unless they have an election change event. And so that the POP document is where those events are described. Because while most people adopt all of the events allowed by the IRS, you don't have to. Okay? So if there's an event that the IRS would allow a change, but it's not in your document, technically employees can't make that change. Even when a change is allowed, you may want to put restrictions on it. So health FSA is a great example of that. You may have a valid event that allows the employee to change their FSA election, but a lot of employers have a restriction that says, but you can't reduce your FSA election below the amount of claims you have submitted already. If you want to do that, that's fine, but you got to put it in the document. Most employers also have rules about how much time do you have to request a change after the event occurs, 30 days being very common. That's not actually set by law. That's actually set by the POP document. So ideally, your POP document should be describing how long employees have after an event occurs to request the change. Runout periods. How long after the end of the year do employees have to submit documentation to get claims out for the prior year? Again, that's set by the plan. Are there expenses that are valid medical expenses, but the FSA is just not going to cover them? Now, usually we don't put that in the POP document itself. We usually point to another document which lists all those out. But nevertheless, that's fundamentally where it goes. Grace periods and carryovers. Not only one, do you have them, but there's a lot of choices to be made there. So, for example, if you have a health FSA with a carryover, do I have to make a new election in the FSA next year to get the carryover? Or do I lose my carryover if I choose to waive coverage on the FSA next year? that's a choice. You have to make that choice. The POP document is where that choice is going to be documented. Pay and chase rules, if you have a debit card, usually go in the POP document. Dealing with HSA disqualification for general purpose health FSAs, the IRS gives various ways to get around that, but again, it has to be documented. And then what happens if we fail non-discrim, cafeteria plan non-discrim testing, or the health FSA or DCAP? Very often the POP document will address those things too. So our last slide here, distributing the POP document. Now, interestingly, unlike ERISA, which has very specific timeframes and rules about distributing electronically and when it has to be distributed, the POP document, actually, there isn't a formal requirement to distribute it. It's required to be in writing, but there is actually no formal requirement to distribute the thing, which is a bit weird, but nevertheless, there you have it. But just be careful. Keep in mind, again, the health FSA is an ERISA plan, so that would need its own SPD, would follow the SPD rules. But the general POP document, there are no formal distribution rules. But it kind of defeats the point of even having a document if employees at least can't access it. I mean, I get it. Nobody's going to sit down and read the cafeteria plan document for, as their nighttime reading. But it is a good idea to make it available so that people can at least make themselves aware of the rules. But also, it's something to point to when somebody comes to you and says, "I want to drop the selection," and your answer is no, and they say, "Well, why not?" You can point to the POP document and say, "Because IRS rules are documented here." You've got something to point to that they can see where that comes from. Okay. So we generally recommend you make the POP document available the same way you do your SPDs and other plan docs, email, intranet, what have you. You just don't have to follow those same formal ERISA electronic distribution rules. You can just post the cafeteria plan document on the intranet, and that's good enough, even for the people who don't have regular work-related computer access. Okay. So actually, we had a couple of questions, and this is on electronic distribution. So I want to take these because they kind of fit in with what we've been talking about before we get to our final wrap up here. So first, the person asked, what about company issued phones that is used regularly for work? Or I had a locksmith out the other day, and he had some, it wasn't just a phone, it was a more sophisticated, but a handheld tablet. Does that count? Is that computer access where they have a company issued phone and they use that regularly to do their job? You have to keep in mind the electronic distribution rules are from like 2002, 2004. They're over 20 years old. They talk about floppy disks, for God's sake, and CD-ROMs. So they're a bit dated. So unfortunately, sometimes it's not clear. I mean, I think I would make a pretty good argument that a modern smartphone is a computer. And if it's being used, if that's a regular part of their job is they have to use their smartphone, then I think that probably does count. But we can't say for sure. Now, on the other hand, so somebody asked this question. So if we have employees that don't have computer access, they work in a manufacturing environment, but can use their phone to access the documents via the app, that does not qualify unless we get consent. I think that's right. They're not using the phone for their work. And so I don't think that counts, even though it seems ridiculous. Everybody has a phone. I have employers who the employee clock in and out using their phone. But are they using it for their job? No. And again, these rules are old, they're outdated. It may seem ridiculous, but I think technically the answer is no, you have to get consent to do that. Now, it is a safe harbor. You can certainly roll the dice and say, we're not going to do it. And if anybody challenges it, maybe you win. But no, if they're not using it as part of their job, I don't think it counts. I don't know, Brianna, if you have any other thoughts on that.
No, same as you. Same thoughts on that one.
Okay. So a couple other questions before we just wrap up here. So does that, going to cafeteria plans, does that mean if an employee wants to voluntarily drop their health insurance coverage, they can't unless it is an open enrollment? That is exactly what that means. If they're paying their health insurance pre-tax and it's not open enrollment,
Yeah, thanks, David. Appreciate it. And Brianna as well. Thank you very much for all the info that you guys provided. Really, it's a lot of information. It's always kind of hard to keep track of it, but hopefully for our listeners, you were able to get some takeaways there. That's about as concise as we can make some of that topic. But really appreciate you guys exploring that with us. If you have additional questions, please reach out to the benefits advisor who invited you here today for any additional assistance. And as a reminder, they can also provide you with a link to the recording that'll be available early part of next week. And again, thanks to all those advisors and consultants who are partners of AssurexGlobal for helping sponsor our event today. With that, we'll conclude. Enjoy the rest of your week. Thank you.
Thanks, everybody.